Good afternoon, friends. So today I am going to discuss the issues surrounding the death of a person, whether the proceedings which have been initiated prior to the whether any proceedings which has been initiated against a deceased person or a struck of companies, whether prior or after the death or the non-existence or the striking of the company, and whether a recovery of tax can be made from the estate of a deceased person, whether a notice can be issued in the name of a deceased person, whether the notice can be issued in the name of a legal heir or a legal representative, and the tax, the effect of merger or acquisition. And I am going to discuss these issues from the perspective of both Income Tax Act as well as the GST law. First, I will start the discussion under the Income Tax Act. So under the Income Tax Act, the relevant provisions are Section 159, Section 292 capital B, and Section 292 capital double BB. Why Section 292B and 292 double BB of the Income Tax Act are relevant? As I discuss, I will state the importance of these provisions. But first, let me deal with Section 159 of the Income Tax Act. Section 159 envisages two situations or two circumstances. One is where the assessment proceeding has been initiated while the person concerned was alive. Then the question arises is whether it can be continued against his legal representative. Second is if the proceedings were not initiated prior to the date of the person, then what can happen? So as far as the situation whether assessment proceeding has already been initiated against a deceased person, then Section 1559 says that it can be continued against the legal representative. Second situation is where proceeding has not been initiated. So if the proceeding has not been initiated at all, then notice for assessment or reassessment. So no notice under Section 143 or 148 can be issued to a deceased person in the name of the deceased person. So if any notice is issued in the name of a dead person, then such a notice is invalid in the eye of law, and one can write to the assessing officer that since the person is no more alive, so the notice itself is invalid, and you need not respond on the merit of the case. Even though Section 292 capital B says where any notice is issued, then it should not be invalid merely by reason of any mistake, defect, or omission in the said notice or summon or proceeding, provided that the such notice is in substance and effect in conformity with and according to intent and purpose of the Act. So if there is any defect, mistake, or omission in the notice, then the notice will not be invalid merely for that reason. But a notice issued against a dead person cannot be considered to be valid at all. And such notice the defect in such notice goes to the root of the matter, and it cannot be cured by what is stated in Section 292 capital B. Now the second issue which arises is, suppose the notice is issued against the dead person and his legal representative participates in the proceeding, then what happens? Then the answer lies in 292 capital BB. It says that where an SSC has appeared in any proceeding or cooperated in any inquiry related to an assessment, it shall be deemed that any notice which is required to be served upon him has been duly served upon him in accordance with the provision of the Act, and such SSC shall be precluded from taking any objection that the notice was not served upon him or not served upon him in time or served upon him in an improper manner. But here also, and according to me, just because a legal representative appears before the authority, it does not mean that the defect in issuance of the notice under section 290BB can be cured merely by participation. Because the participation has to be by the SSC. And the SSC, in the case of a dead person, is the legal representative and not the dead person himself. A dead person cannot come and make any representation. So notice, if it has not already been issued, then it should be issued in the name of the legal representative only. And if the notice is not issued in the name of the legal representative, then in my view, it cannot be cured by section 292B or 292 capital BB. Now, while we are in the Income Tax Act, I would also like to discuss the situation of notice issued in the name of a struck-off company. Suppose a notice is issued from the registrar of the companies, and the notice is issued in the name of the struck-off company, then whether such a notice is valid. Again, the same law applies, and there are a number of judgments in this regard, which says that a notice issued in the name of a struck-off companies is invalid because a company which is dissolved ceases to exist in the eye of law, and there cannot be, and such a person cannot be treated as a person at all. The framing of assessment against a non-existing entity goes to the root of the matter, and which is not merely a procedural irregularity but a jurisdictional defect, as there cannot be assessment against a dead person. So there are a number of judgments in this regard. Now, there Supreme Court judgment is there in the case of Principal Commissioner of Income Tax versus Maruti Suzuki India Limited. It is a judgment dated July 25, 2019 in Civil Appeal number 5409 of 2019, wherein Honorable Supreme Court has held that if a company has amalgamated with another company and thereby lost its existence, then assessment order passed subsequently in the name of the non-existing entity would be without jurisdiction and liable to be set aside. So as we can see that even the amalgamated company, even though it exists and merges with some other company, there can be no assessment against such a amalgamated company. So therefore, I think there is no question of any assessment whatsoever valid against a dead person or a struck-off company. So this is the discussion as far as the Income Tax Act goes. Now here one important matter, one important issue which I would like to point out, that suppose a company has been struck off and subsequently the income tax department discovers that there is any liability which needs to be recovered. They want to proceed, that there is some escapement of income and then want to proceed under 148. Then the only recourse available to the department is to approach NCLT under section 252 of the Companies Act, read with rule 11 and 87 of the NCLT rule, for the revival of the company. After the company is revived, it is open for the department to initiate proceeding under section 148 of the Income Tax Act. So until unless the company is revived under 242, the notice cannot be issued or no proceeding can be taken. And this can only be done within 3 years of the striking of the company, because the company law itself says that if the company is struck off, then prior to striking off, a notice is issued to the income tax department. So income tax department cannot wash their hands off and say that we were not aware of the company being struck off. So therefore, we could not recover the liability. Now coming to the GST law. Now here under the Income Tax Act, one important aspect is that section 159 says that the recovery from the legal representative can only be to the extent of the estate of the deceased person. So under no circumstance, the liability which has to be recovered either in terms of tax, interest or penalty exceed the assets which have been left behind by the dead person after deducting his liabilities. So it can only be to the extent of his assets and not beyond that. So it is not that the legal representative entirely steps into the shoes of a dead person. He steps into the shoes of the dead person only to the extent of his assets. Now coming to the GST Act, section 93 of the GST Act is with respect to the carrying on of the business by a dead person or the liability of a dead person, how it is to be recovered. There can be two scenarios. One is where the business is continued post the death of a person. If the business is continued, then any person who continues the business will be liable to pay tax. So there is nothing which needs to be discussed about this. Now the question is with respect to a scenario where the business is discontinued. Now here again the legal representative shall be liable to pay and only to the extent of the estate of the deceased person. And under the GST Act also, no notice or assessment will be valid in the name of the dead person. Once the person is died, then he will have to be suitably replaced by the legal representative. And if notice is not issued at all, then the notice can of course be issued in the name of the legal representative. But if the notice is issued in the name of the deceased person itself, then such a notice will be invalid. Now I come to some other aspects where suppose the business is transferred. So if the business is transferred by way of sale, gift, lease or leave license or hire or in any other manner, then the transferor and transferee both shall be jointly and severally liable to wholly or partly pay the tax, interest and penalty due from the taxable person till the time the business is transferred. Now, what happens in the case of amalgamation or merger? Now, in the case of amalgamation or merger, we know that in the scheme of the amalgamation, usually a date is given with effect from which the amalgamating and amalgamated company intends the order to be effective. For example, the order for amalgamation is passed on 14/12/2024. But the scheme of amalgamation says that it will be effective from 1st of April 2023. But what the GST law says is that for the purpose of the GST Act, the effective date will be 1st 14/12/2024. And the date mentioned in the scheme of the amalgamation will be ignored as far as the GST law is concerned. For the GST law, the cancellation of the registration of the amalgamated company will be effective from the date of the passing of the order by the NCLT and not the date mentioned in the scheme of the amalgamation. And any business done between the two companies prior to the amalgamation will be treated as a transaction between two distinct persons and will be accordingly taxable. Now, what happens in the case of liquidation? Now, in case of a liquidation, the IBC Act takes precedence over the GST law. So, the liability will have to be discharged in accordance with the waterfall mechanism as specified in IBC Act. Now, there are several Supreme Court judgments which says that IBC code will prevail over tax laws. There are two judgments, or rather I will refer to only one judgment in the context of Income Tax Act, Principal Commissioner of Income Tax versus Monet Spath and Energy Limited, wherein it was held that the IBCT code will override anything inconsistent contained in any other enactment, including Income Tax Act. And the same goes for the GST law also. Now, here I wish to point out one important aspect which was decided in Ghanshyam Mishra and Sons Private Limited versus Edelweiss Asset Reconstruction Company Limited, that any dues to the central government or tax, state government, or any local authority, including tax, will only be valid to the extent that the amount is mentioned in the resolution plan. So whatever is not paid in accordance with the resolution plan, that debt of the income tax department of the GST department will extinguish. So if the company has been dissolved, or say the company has been transferred to a new entity by virtue of IBC code, then the IBC code will prevail, and Income Tax Act and the GST Act will not prevail. And the manner in which the waterfall mechanism as per IBC code is there, the distribution of the assets of the company will be in accordance with that or as per the resolution plan. So with this, friends, I conclude my today's session. Thank you very much.